Question 16. Can I get a credit card after bankruptcy? Answer: yes, there are several options available. While technically not a credit card, you could use a bank or debit card to perform activities for which you normally would use a credit card. You also may be able to keep the credit card you already have if the creditor grants approval. If these options do not work, you can get secured credit card which is backed by your own bank account. Question 17. Are utility services affected? Answer: public utilities, such as the electric company, cannot refuse or cut off service because you have filed for bankruptcy. However, the utility can require a deposit for future service, and you do have to pay bills which arise after your bankruptcy is filed. Question 18. Can I be discriminated against for filing bankruptcy? Answer: Number 11 USC 2nd 525 prohibits governmental units and private employers from discriminating against you because you filed a bankruptcy petition or because you failed to pay a dischargeable debt. Question 19. How does bankruptcy help me in the short run? Answer: the moment you file for bankruptcy, you are protected from your creditors. The automatic stay stops all collection efforts against you and against your property. Creditors must stop calling you and sending letters to you. If a creditor has already sued you, that lawsuit must stop. The automatic stay also prevents creditors from repossessing your property and from foreclosing on your home. Question 20. What is a discharge? Answer: if a debt is discharged, you no longer have an obligation to pay the debt, and the creditor may not make any effort to compel you to repay. However, if some other person, such as a relative or friend, has co-signed or guaranteed your loan, his/her obligation is not discharged. In addition, if you have property that is collateral for a loan, the creditor may still be able to repossess that property if you do not repay the loan. Question 21. I'm married. Can I file by myself? Answer: yes, but your spouse will still be liable for any joint debts. If you file together, you will be able to double your exemptions. In some cases where only one spouse has debts, or one spouse has debts that are not dischargeable, then it might be advisable to have only one spouse file. If the spouses have joint debts, the fact that one spouse discharged the debt may show on the other spouse's credit report. Question 22. Can bankruptcy help get my California driver's license back? Answer: if you lost your license solely because you couldn't pay court-ordered damages caused in an accident, bankruptcy will allow you to get your license back. Question 23. How long after filing will the creditors stop calling? Answer: once a creditor or bill collector becomes aware of a filing for bankruptcy protection, it must immediately stop all collection efforts. After you file the bankruptcy petition, the court mails a notice to all the creditors listed in your bankruptcy schedules. This usually takes a couple of weeks. Creditors will also stop calling if you inform them that you filed the bankruptcy petition and supply them with your case number. In some cases, you or your attorney should contact the creditor immediately upon filing the bankruptcy petition, especially if a lawsuit is pending. If a creditor continues to use collection tactics once informed of the bankruptcy, they may be liable for court sanctions and attorney fees for this conduct. Question 24. Can I raise my student loans by filing bankruptcy? Answer: generally, student loans are not discharged in bankruptcy. In 11 USC 2nd 523A(8), there are two exceptions to this general rule. The student loan may be discharged if it is neither insured or guaranteed by a governmental unit, nor made under any program funded in whole or in part by a governmental unit or non-profit institution. The student loan may be discharged if paying the loan will impose an undue hardship on the debtor and the debtor's dependents. Student loans more than 7 years old used to be dischargeable under certain circumstances, but this provision was removed by an appropriations bill passed in October of 1998. Whether an exception applies depends on the facts of the particular case and may also depend on local court decisions. Even if a student loan falls into one of the two exceptions, discharge of the loan may not be automatic. You may have to file an adversary proceeding in the bankruptcy court to obtain a court order declaring the debt discharged. Question 25. Where do I file if I haven't lived in the same state or district for the last 2 years? Answer. If you haven't lived in your current state for 91 days, you must wait until you have lived there for 91 days and then file in your current state. If you lived in your current state for more than 91 days but less than 2 years, you will file in your current state but use the exemptions from where you lived for majority of the 180-day period immediately previous to the 2-year period before you filed. If you bought your home within the last 40 months and or haven't lived in your current state for the last 2 years, then your homestead exemption may be limited. Question 26. If I am going through a divorce, how will my ex-spouse filing bankruptcy affect our divorce settlement? Answer. Alimony, maintenance and or support are protected from discharge. Divorce decrees and separation agreements are covered by 11 U.S.C. Section 523A-15. This section states that these debts are not dischargeable unless the debtor does not have the ability to pay such debt from income or property of the debtor not reasonably necessary to be expended for the maintenance or support of the debtor or a dependent of the debtor, and, if the debtor is engaged in a business, for the payment of expenditures necessary for the continuation, preservation, and operation of such business, or discharging such debt would result in a benefit to the debtor that outweighs the detrimental consequences to a spouse, former spouse, or child of the debtor. Question 27. What should I do if a creditor demands payment of a debt after I file my case? Answer. Most efforts by a creditor to collect a pre-petition debt, one that you owe as of the filing of your case, or to repossess your property without the permission of the bankruptcy court are violations of the automatic stay. If a creditor repossesses any property, such as your car, after you file for bankruptcy, the creditor must return the property to you. The court may punish a creditor who knowingly violates the automatic stay, and the creditor is liable to the debtor for harm caused. If you did not list a debt on the schedules filed with the court, the creditor may not be on notice of the bankruptcy. Therefore, you should inform the creditor of your bankruptcy and request that the creditor stop the collection efforts. If you are represented by an attorney, you should give the creditor your attorney's name and telephone number. If you are not represented by an attorney, you should give the creditor additional information about the case, the date of filing, the court in which the case was filed, and the case number. If improper collection action continues, you should consult with an attorney, notify the trustee, or seek protection from the court. Question 28. What should I do if I discover that I forgot to list a creditor in the bankruptcy schedules? Answer. You should notify your attorney and provide him or her with all the information necessary to complete the schedule, the amount of the debt, the type and value of any collateral, and the name and address of the creditor. This is very important, because if you do not list a debt on your schedules, that debt might not be discharged. That means you will be required to pay the debt in full after bankruptcy. If an omitted creditor demands payment of the debt, you should inform the creditor of the bankruptcy, as discussed below. Question 29. Do I have to list all creditors on the bankruptcy schedules? Answer. Yes. You must list all your debts with the name and address of the creditors. This is so creditors receive notice of the bankruptcy and get their fair share of any money paid to creditors. You may think that you should omit a creditor because you want to continue to pay the debt. This would violate the law, and it is unnecessary because you can always choose to pay a debt voluntarily, even though the debt has been discharged and there is no legal obligation to make payment. However, creditors are prohibited from taking any action to collect discharged debts. Question 30. Must I produce tax returns before and after my bankruptcy? Answer. Yes. You must provide the trustee and or any creditor with copies of any federal tax return that you filed for the year prior to filing. If you do not comply with this request, the court may dismiss your bankruptcy case. You must also file copies of any federal tax returns filed during the case with the bankruptcy court. Any taxing authority may request dismissal of a bankruptcy case if you fail to file all required tax returns.